If a tenant remains in occupation for the purposes of its business, a protected lease does not come to an end at the end of a contractual term. Instead, it continues on exactly the same terms and rent until it is formally brought to an end under the Act. This is known as a continuation tenancy, or sometimes as holding over. The provisions relating to termination of continuation tenancies under the Act and the statutory renewal process generally are very complex, but I'll try and give you a brief overview of the process for a renewal lease that is unopposed by the landlord. The process usually starts with either the landlord serving a statutory notice under Section 25 of the Act to bring the continuation tenancy to an end and propose terms for a new lease, or the tenant's service of a statutory request under Section 26 of the Act for a new lease and again proposing terms. There are very strict requirements that need to be adhered to as to the form of the notices, the dates that can be specified in them, and for service generally. Even very minor infractions can lead to a notice or request being invalidated or being left open to challenge, so it is very important to take legal advice. The proposed terms set out in either a Section 25 notice or a Section 26 request are non-binding, and they're commonly seen as a starting point for further negotiation between the parties.